Good morning, Ms. Barnwell.
Good morning, Your Honor. My name is
Ms.
Hayne.
Barnwell, I don't want to put you in a hot spot, but I just want to mention to the people who have filed various memoranda, amicus briefs, and others, the two United States Supreme Court cases which were at issue in part of this case were decided some months ago. And I just want to remind the bar it's very difficult for the justices when we get memoranda as late as yesterday asking us to consider various points that are being made. So even though there was new law since the filing of the original briefs, it would be very helpful if you could get your submissions in a more timely manner to allow us to really consider what you have to say. That's not directed personally to you, Ms. Barnwell, of course.
Yes, Your Honor. Yes, Your Honor. My name is Hayne Barnwell. I'm from Kearney and Basil. I represent Aaron Powell on appeal. The Massachusetts firearms statutes at issue here prohibit, absolutely, 18-year-old adults from possessing or carrying firearms. By contrast, 18-year-old adults have the right, indeed the obligation at times, to fight for this country.
If I could ask you, do you agree that it is constitutional to prohibit handguns in a school, or for that matter, in a courthouse?
Heller did say that those kinds of regulations were presumptively lawful.
Because they were supposedly, sensitive places?
A sensitive place is what the court
said.
said.
Now, is it unreasonable for a legislature to determine that a student should be as safe from the risk that a fellow student will possess a firearm when she is in the school, or when she leaves the school and goes to the street as she is when she's in the school? Why is a street any less sensitive a place than a school or a courthouse?
Well, first of all, Heller did not discuss any public street as a sensitive place.
So are you suggesting that perhaps Heller is limited to the home?
No, Heller is not limited to the home. Heller explicitly held that the right to keep and bear arms means the right to possess and carry firearms in case of confrontation, is the exact quote.
But there could be a confrontation in a courthouse. I guess the question is, why can a court say that we wish to be safe in a courthouse, but a legislature can't say that every person in this Commonwealth doesn't deserve the same entitlement to be safe on a city street?
Well, Heller did address that, and Heller held that there are certain policy choices that are off the table for the legislature to do. And one of those is to completely deny a person a handgun, whether in the home or outside the home. Which is what is going on in this statute.
But Heller addressed only a firearm statute which spoke of in the home. I mean, it didn't speak of anything outside the home, nor for that matter did Chicago versus McDonald. Those regulations specifically addressed possession in the home. Are you saying that there is explicit language in either Heller or McDonald to say that the public is not entitled to be as safe on a city street as they are in a courthouse or in a school?
Well, respectfully, I disagree. What Heller held was that there's a fundamental right to bear arms. The core of that right is self-defense, and it extends to outside the home. Heller made that very clear. It goes at length talking about what bearing means. What does bear mean? Bear means to carry. And it said in any case of confrontation. So clearly the core is not just the home. The core is self-defense.
That's clear. Let me see if I can ask Justice Ganser's questions a different way. You mentioned quite correctly that we ask 18-year-olds to do all kinds of things, including serve in the military. Is it impermissible for the legislature to recognize that when one carries arms in the military, you are trained, you undergo an extensive training, and yet we do not presume that somebody who carries a licensed firearm necessarily has undergone training. There's no such equivalent obligation to obtain a license. And so is it wholly impermissible for the legislature to look at a broad category of places and peoples and say, we think this group of people are sufficiently at risk for harming others that we would like to exclude them. And we might include, for example, people who have a prior criminal conviction. Oh, you'll say, well, that's obvious, not so obvious if the criminal conviction had nothing to do with guns. They're just categories of people. So what is it that's so fundamentally wrong about having a category of people which is age-based?
Well, Your Honor is correct that Heller did mention presumptively lawful bans.
No, I know. I'm just asking you.
Oh, no, it is not permissible for the legislature to absolutely deny these
Why?
people.
Why?
Because they are adults and they're otherwise law-abiding, as this court recognized.
Yes, but we tell adults in different categories to do different kinds of things, don't we? I mean, we can tell 18-year-olds, for example, you can't drink alcohol.
Right, and that's not a fundamental right. And here we have a fundamental right. That's the crucial difference. And this court recognized in Weston. I'm sorry. Did you have a question, Justice?
Well, I guess I would just add to that. Yes, it is a fundamental right, or the Supreme Court has held such. But this is a category that people get out of. That's number one. And even though it's a fundamental right, as the Chief Justice and Justice Gantz are saying, there are categories of people who can't exercise their fundamental rights. So if there are reasons why this group for a limited period of time cannot exercise that fundamental right, why is that so wrong?
It's still an absolute deprivation, whether it's for 1 year or 3 years. And in this case,
Not absolute, because the person will grow out of it. It's not forever.
Not like a felon.
So for 3 years, the person has no way to defend themselves legally with handguns. I mean, that's the real problem.
Well, that's a policy question. I'm trying to get to the legal basis. We don't exactly follow the jurisprudence of the United States Supreme Court, but for these purposes we will, that there are different categories of rights and classes, right? There's a fundamental right. But the jurisprudence isn't simply because there's a fundamental right involved, there cannot be regulation. So there can be regulation of fundamental rights. I mean, that's obvious. So the question is the debate here simply a policy one that the legislature hasn't established based on some record why they selected these 3 years, 18 to 21? Or is your argument simply you can't regulate here because there's no conceivable set of circumstances that this would withstand scrutiny?
Well, I'm certainly not making a policy argument. I'm making a constitutional one. And if we all recognize there's a Second Amendment fundamental right to keep and bear arms. It's now the Commonwealth's burden to provide a compelling interest that's narrowly tailored. They haven't shown that here.
But do you agree that there's a compelling interest in licensing individuals to carry firearms?
Yes, I'm not challenging the licensing
Okay.
scheme per se.
So there's some regulation.
There's some regulation, and that's fine.
So your legal argument, as long as they can show a compelling interest narrowly tailored,
that supports its complete ban of 18 to 20-year-old adults from having firearms in the first place. You have to get a license in order to have a firearm. I mean, that's how Massachusetts.
Yeah, but if you have I don't have to get a license to speak. I've got a fundamental right to speak. I don't have to get a license to speak on the corner of the Boston Common. You know, the mayor could try and do that for me. Don't think that would withstand scrutiny. So you've already conceded a huge amount by saying you can license this.
I don't think so, because again, I'm not challenging the licensing scheme. I'm challenging the fact that the Commonwealth has completely banned a narrow class of adults from having firearms without providing a compelling reason for doing so.
Can I ask?
That's the claim.
In this case, though, if you're not challenging the licensing scheme, and you have a police officer who's looking at somebody, doesn't know how old he is, it's night, it's a lot of people running around, could there not be a reasonable suspicion that this is somebody who may well be over 20 but isn't licensed? I mean, as applied to this case, even if you say that it's impermissible to ban licenses, but say you could, the court could interpret the statute so that it didn't have that absolute ban, but otherwise the licensing was fine. What about as applied to what reasonable suspicion may mean?
Well, this court has already held, I think correctly, that possession of a firearm alone is not a crime. And what's interesting as far as I'm sorry?
That's true.
Right.
But I don't know that necessarily
But if someone is acting so that it gives reasonable suspicion to the police to believe that it is an illegal weapon because the person is clutching at his waistband, running away from the police, dropping it, if it were legally possessed, the individual most likely would not be acting like that. So wouldn't the actions in this case give rise to the reasonable suspicion that it was illegally possessed?
Well, first of all, he dropped it in response to a police order to drop it. So I don't think that's not abandonment. The second thing is that
I'm not suggesting there was abandonment. I'm just saying the way he was running, clutching it at his waist. First of all, he had it concealed. Secondly, he's kept running and clutching at his waist as if it were being illegally carried.
Well, I mean, the district court actually found that there was reasonable suspicion that he had a firearm. That was the only finding, actually. It wasn't that he possessed an illegal firearm or that he was unlicensed.
Well, but
So I think we can read from that.
His conduct
implicit as
suggested he...
unlawful.
Well, however this court decides the suppression issue, I think at the very least at trial, the Commonwealth has the burden to prove, especially after Heller and McDonald, that my client had an unlicensed firearm, and they didn't do that in this case.
Well, let me ask you this. We're in a rather unusual historical moment here because these were statutes that were enacted by the Massachusetts legislature when I think it is fair to say that nobody thought that there would be a fundamental right to bear arms that was applicable to the states. Unlike, for example, when Congress recently has attempted to regulate speech in some kind of way, so there are extensive hearings. To what precedent can you refer that says that when a fundamental right is established in the way that the Supreme Court has now done it, and there's an existing statute, how do we tell whether there is a compelling interest that has been narrowly tailored? In other words, very effective counsel for the Commonwealth can come up with whatever good policy argument she wants to come up with, but that's not the legislature speaking. I mean, I'm trying to have your assistance in helping me determine how I go through the constitutional steps here.
Well, I think the first thing you would do is to turn to the Commonwealth and ask the Commonwealth to provide evidence in the form of, it can be statistics even, it doesn't even have to be in the legislative record.
But that's not the legislature acting. I mean,
that's right.
That's not the legislature acting, and it cannot be, I don't think it is, and I don't think there's any such case that says when there's been a fundamental right recognized, or, for example, when a fundamental right has been applied to a certain activity, for example, the application of the First Amendment to libel law. Nobody thought for 200 years that the First Amendment had anything to do with libel law. All of a sudden it was applicable to libel law. Does that sort of undo any regulation? It seems to me that what you're asking us to do is to say the United States Supreme Court has issued a ruling which we have to respect, and therefore any regulation in any way you've conceded licensing, but the next person might not concede licensing. You have, but the next person might not. We just say, well, there's no compelling interest here. How do we determine if it's narrowly tailored, if there's a compelling interest?
This is not like other regulations. I know I'm repeating myself, but this is an absolute ban against a status of individuals. So I'm not sure what the legislature...
Where do we see the ban against the status of individuals?
Because they're from 18 to 20.
No. You said there's an absolute ban as if Heller had addressed the issue, or McDonald had addressed the issue. I don't think we've looked at the status of individuals, whether it's by age or by location or by, prior history of some kind.
Well, this court could just turn to Heller itself, because Heller itself is very clear that individuals, it's an individual right. My client is an individual who is an adult, who at the time was otherwise law-abiding, and so there's no reason, the Commonwealth itself had no reason to completely ban people like my client from just having a firearm.
But isn't that in large part because this issue was not raised below? I'm not suggesting waiver and that we may not take up the issue anyway because it's such an important one, but maybe we won't because the record isn't appropriate. You say the Commonwealth presented no evidence, But this issue wasn't below, so we don't know what evidence they would present if it were raised properly.
Well, first of all, I don't know. I mean, Chief Justice Marshall mentioned what could we find? What could the legislature do in terms of a record? For this
That's
court?
correct, but I'm saying here we lack the record because the defense did not raise the issue at the appropriate point.
But my point is that the legislature, there's no record that I can imagine that the legislature can bring this court that would show a compelling interest to ban 18 to 20-year-old adults.
Can I just go back to something that you said? You said, my client's an adult. Who made your client an adult?
It is the practice of the United States.
Who made your client an adult?
By turning 18.
And who said 18 you become an adult?
The Commonwealth of Massachusetts treats 18-year-olds as adults
For certain purposes.
For the purpose of all fundamental rights.
But it's the legislature.
So it should
that
be
does
this one as well. It should apply equally to this one. If we're going to say that they have the right to vote, they have the right to marry, indeed they have the right to take offensive and defensive action in the military, where of course they're using firearms. Then
After they've been carefully trained, as I said.
Well, again, so the Commonwealth can narrowly tailor this. 18 to 20-year-old adults, you have to take more training before you can be licensed to have a firearm.
But in the military, they're supervised.
But this is an absolute ban.
In the military, they're supervised. Can't we presume that the legislature was trying to protect 18 to 21-year-old people who don't necessarily have the best judgment when it comes to handling inherently dangerous items? Marriage and voting are not inherently dangerous. A gun is an inherently dangerous item. And to entrust something like that, even with a fundamental right, somebody between 18 and 21 just doesn't have the appropriate judgment or level of judgment in order to have that kind of an item.
I see my time is. Can I just make 2 quick points in
You can
response?
answer the question, certainly.
Okay. Your Honor, as this court recognized in Weston W., it's an important case from this court, fundamental constitutional rights do not magically arise at the state-defined age of majority. That's the first thing. The second thing is, no, we can't presume that the legislature determined that somehow 18-year-olds lack judgment. And even if that is true, even if this court takes judicial notice of that, that doesn't give them the right to do this absolute ban. It doesn't.
If I could, does it matter that this case comes to us in the posture of a criminal prosecution where this is being raised as a defense as opposed to the posture of your client applying for a license to carry and having been denied on the basis of his age?
Under Commonwealth versus Gordon, a person does not need to apply for a license in order to raise a challenge to the licensing statute. So that would be my answer to that.
But is it clear that your client, but for his age, would qualify under the licensing scheme for a license?
The Commonwealth does raise that. Again, a quick point. First of all, it's not the defendant's burden because it's their burden to prove a compelling interest, and they could show compelling interest perhaps by saying
Well, what if your
he would
client
have
was
been otherwise
convicted?
disqualified.
But what if but we've got no record. Has your client been convicted of a felony?
No, and this court can actually see that at the sentencing hearing. There's a sentencing transcript at the very end, and the prosecutor actually says, Aaron Powell, I realize, Your Honor, has no criminal record, indeed has no involvement with the criminal justice system, but et cetera, you have to do the minimum mandatory of 18 months, and it goes on. And then defense counsel gets up and says he wanted to join the military. That's the real sad irony here. He wanted to join the military, and now he can't. So,
Counsel, before you sit down,
yes.
I understand you're making a constitutional argument, but on the public policy perspective, do we want 18-year-olders walking around with guns?
Well, I think this sort of relates to the point of, weapons are dangerous, and we don't want to cause danger in the streets. Justice Scalia answered this quite well in Heller, which was the thing that makes weapons dangerous make them also very useful for self-defense. And so we do have that policy conflict with the constitutional argument, but Justice Scalia's point is the Constitution trumps that policy concern.
All right. There's no record here developed below with respect to the background leading up to the legislature's complete ban on firearm licensing for persons under 21. But indeed, there is such a record. As you may be well aware, the debate over handguns raged in this Commonwealth for at least 10 years. with serious concerns about young people having guns that arose out of hundreds of murders in the 1980s and 1990s. Since no record has been developed, since the matter wasn't raised in the trial court, can we ask that a record be presented to us of the legislative history of this? Or can we do our own assessment of the legislative history?
Well, the Commonwealth did have an opportunity to present that record to this court. It didn't do so. I suppose this court
On
could-
appeal, not
this
in
court,
the
no, this
trial.
court, this court can look at the legislative history. I think that's perfectly appropriate. But the problem is, yes, murders are terrible, and the streets can be frightening. But the streets can be frightening equally for innocent citizens, like my client
You're
is walking
suggesting
around
if
the
everyone
street.
had a gun, we'd be much safer.
No, that's not what I'm arguing. I'm arguing what Heller says, which is, yes, we recognize the important policy concern about murder, about crime, but that doesn't give the state the right to completely ban individuals from handguns.
Justice Cowan?
Yes, thank you. I understand that your constitutional argument is your strongest one, but if you lose on that, how can you distinguish this case from Commonwealth versus Franklin?
Oh, I'm sorry. Is this the resisting arrest? Or
On
is
the
this
motion to
suppression?
on the motion
I'm
to
sorry.
suppress. I could also ask you the same question on the resisting to arrest and the distinction between.
Yes, I did want to briefly note that his resisting arrest conviction should also be reversed because there's insufficient evidence of an arrest. Actually,
But how do you distinguish this case, the decision on the motion to suppress, from the decision of Commonwealth versus Franklin?
Messiah Franklin, that's right. I think the difference between that, I believe there was a concurrence by Chief Justice Marshall.
Forget that. I'm
Okay.
asking from the
I'm
majority
sorry.
opinion. I'm asking you from the majority opinion. How do you
Yes, the
distinguish
difference
the
is
facts?
the difference is that
You're talking to the author.
I apologize. The difference is that this court did not have a record of the suppression hearing, even I think in that case,
Yes,
and
we
so
did.
it didn't have it didn't know how close the police were to the defendant. Whereas here, there was testimony that he was only, I believe, one car length away, so about 6 feet away, and two officers were chasing my client. It's clear that they're trying to grab the guy. They're trying to seize him, and an attempt to capture is the same as a seizure.
Thank you very
Thank
much.
you, Your Honor.
Thanks, Ms. Barnwell. Good morning, Ms. Celia.
Good morning, Your Honors. May it please the Court. Kathleen Celio on behalf of the Commonwealth. With me is Ryan McLaughlin, student intern, who was on the brief in the appeals court. With me is also Gregory Henning, the trial and motion prosecutor on this case.
So you're going to help us understand what the United States Supreme Court has asked us to do.
I am.
Good.
Before you do that, do you concede that your letter of October 5th is wrong when you say that citizens in Massachusetts as young as 15 years of age have the right to possess a firearm in the home?
No.
Is that wrong?
No.
So they do.
Yes.
So a firearm, we're talking about the statutory definition of a firearm,
Correct.
can be possessed by someone as young as 15 in the home or in his or her place of business.
With an FID card, because you have to get a parent's permission, 15 to 18, and over 18.
This is handguns. We're not talking about rifles.
Right. This is handguns.
We just got a letter this morning, and
Correct.
that's why it's so impossible for us to absorb
no, I
all this
understand.
at this point. When these decisions have been out for months, we've gotten 3 or 4 submissions this week, including this morning. But the other side says that there is an absolute ban on possession of a handgun in the home.
No. If you look at 129B, Section 6, which the amicus of Goal has set out, it limits certain guns, and it uses the phrase right here, a firearm identification card can entitle holder thereof to possess, shall not entitle to possess, and then it goes 1 and 2, and they're pointing obviously to 2. But if you look at itself, you go to, it involves, they use the word possess, but in terms of looking at the regulatory scheme under 129B and 129C, 131A, which is your ability to get a firearm, under 129A, if you have a firearm identification card and you get a permit to purchase under 131A, that you have the ability to purchase a handgun if you're over 18, you're able to have that handgun.
Well, what about the statute about that requires it being locked in the home?
What, 131L?
No. The one that's at issue here.
No.
Chapter 140, section, the one that talks about having it in the home unlocked unless you're the owner or someone under the control of the owner.
Correct. So if it's under your control in the home,
Yeah.
you can have a handgun. And under one, I mean, just to point out, in 269-10H, which is the criminal statute, which here the defendant says she's not contesting the regulatory scheme. Under the criminal statute, under 269-10H, it is not a crime to have a gun in your home with an FID card.
So I'm just reading from the letter, and,
Yep.
and I'm not asking you to. Well, let me say. Similarly here, this is the defendant's claim. 269, section 10, without the subsection, and 140, chapter 140, 131, without a subsection, categorically ban, 18 to 20-year-olds from possessing handguns inside and outside the home. You would say that's just flat wrong.
That is correct. 'Cause if you look at 269H1, it says that you can, if you own or possess a handgun with complying with 129C, then which is the firearm identification card statute regulation, that it is not a crime to have a firearm in your house with an FID card.
So where does that get us with respect to the challenge here?
Well, he was charged under 269-10A. And so I'm not saying that an FID card at all, if you walk out onto the street, then you're, that's not a criminal act. You have to have a license under 140, 131. 131, and that is only limited to people that are over 21.
So what you're suggesting is, if you look at Heller and McDonald,
Correct.
Persons from age 15 to 20 can actually possess a firearm in their homes.
Without being, that is not a criminal offense under 269.
As long as they have an FID card.
Correct.
Which they can get at those ages.
Correct.
So they have the ability to defend themselves in their homes or their place of businesses. I take it that's your point.
Correct. And I think that if you look at Heller, I mean, the Supreme Court in Heller and McDonald go on and on. But if you look at, they're very clear about their holding. I mean, in Heller, in sum, we hold that the district court's ban on handgun possessions in the home violates the Second Amendment, as does its prohibition against rendering any lawful firearm in the home operable for the purpose of immediate self-defense.
And so is that your response to the defendant's argument that Heller and McDonald say that there is also a right to carry the gun out of the home?
That was never addressed by the Supreme Court. Their holding is very narrow. If you look at McDonald, they say the same thing. In Heller, we held that the Second Amendment protects the right to possess a handgun in the home. And then they say, therefore, the Due Process Clause of the 14th Amendment incorporates the Second Amendment right recognized in Heller. What they recognized in Heller was self-defense, the right to have a handgun for self-defense in the home. And I think that if you look at it, that is the core right of the Second Amendment. They say nothing about what happens when you leave your home, with the handgun and go onto a public street.
Well, it may be the core. I mean, I think there's some other language in McDonald about it's especially in the home, but the core doesn't mean it's the entire right. So you're just saying, I take it that what follows is, if it's not the core, regulation can be more robust once you're out of the home.
That is correct. And I think that if this court looks at the opinion in Heller, and Justice Scalia, I mean, I think at least 13 times analogizes the First Amendment with the Second Amendment. And under First Amendment jurisprudence, there are certain things that are heightened scrutiny because you are getting at the core of the First Amendment. But then there's time, place, and manner restrictions, regulations of how a people choose to regulate that speech, and then that's under intermediate scrutiny. And I think that if you look at what a lot of the federal courts are doing, is that they're taking that into consideration and saying, if it's not, a regulation at the core, which is the right of a handgun and self-defense in a home, then other regulations may require some level of scrutiny, and they've looked at it under intermediate scrutiny, analogizing then with the First Amendment kind of jurisprudence.
But the defendant says this isn't a regulation, it's a ban.
No, it is a regulation
It's a ban
on the
has to be
licensing. It is a ban on people under 21 cannot take their gun and go outside. But I think that it is one. I mean, Heller recognizes that you can have certain what I would call disqualifications,
Right.
and I think that even if you look at Heller's language, they say that assuming that Mr. Heller is not disqualified from the exercise of his Second Amendment right to, then we'll, so I think it's looking at, there are disqualifications that a legislature can impose on the right under the Second Amendment.
So you say intermediate scrutiny. I don't think we've really recognized intermediate scrutiny here, but as a matter of federal constitutional analysis, there really is no record here to give us a real good sense of what process the legislature went through when it adopted this regulatory format as relates to this group. How do we make a record?
Well, I think that is my primary argument in the fact that I don't think this case is properly before the court. I mean, I think this was never an issue. I don't think this was ever an issue. The defendant never raised it. And so in all of usually the claims, the constitutional claims, this court just goes and adds applied of whether or not this was a substantial risk of a miscarriage of justice, and looking at the facts of the case. And there's no facts on the case that show that he was entitled to a license. I mean, even if you were to get rid of and say, okay, at 18, he could have gotten a firearm, a license. The facts of this case, the defendant hasn't showed that, but for his age, he would have gotten a license. And to the contrary, in fact, I think that the defendant's actions strongly suggest that he probably doesn't have the proper training and experience in order to have the firearm. In order to get a license, you have to have taken a proficiency exam under Chapter 1, under 131P.
Sure.
You have to show that you have the judgment in order to carry this firearm. And I think the defendant's actions in this case strongly suggest that he didn't have that.
When was this case tried?
This case was tried in January of 2009. So it was after Heller, but it was before this case. This court said anything on Runyon and DePina.
Now, do you agree with Ms. Barnwell that she cites Gordon, which I see as a case that she's not cited in her brief, that this case can be brought to us as a defense in a criminal prosecution as opposed to an individual applying for a license and being turned down? Is it your view that it's irrelevant whether it was brought as part of a defense in a criminal case or not brought, as in this case, as opposed to a person bringing it as an administrative appeal after having applied for a license and being rejected?
I apologize. I'm not familiar with Gordon, but I think that in terms of a policy, if someone has a problem with a licensing scheme and thinks something's unconstitutional, I don't think the remedy is for them to go just break the law then and say, I don't need a license, I can carry a firearm whenever I want, and anyone can go carry a firearm now. I mean, I think if we analogized it to, say, licensing is to be a lawyer or medicine, if something was unconstitutional.
I mean, one of the difficulties, I suppose, is that at the time that the actions took place, the Second Amendment hadn't been incorporated into the 14th Amendment, and so everybody was on a clean regulatory slate from the Commonwealth's point of view.
Well, I think that if you look at Davis, which is in the 1970s, the reason why the court said that it was not incorporated was because they didn't think it was an individual right. And I think under Heller, that seriously undermined the reasoning that this court had determined in Davis.
No, I understand. But I'm just saying from the Commonwealth's point of view, the conduct at issue here, at least for the two police officers, it was 2 or 3 police officers, the notion that an 18-year-old might have the right to have a gun would probably not have entered their heads because they were simply operating on the then existing law in the Commonwealth.
But I think that would be true. But I think even if the way that the defendant was handling the gun, and I think even if he was 40, I think the police officers would have had the same conduct because he was pulling out a firearm as he was running, and I mean there was a serious concern if the defendant would have turned 1 inch the other way. I think he could have been shot at. I mean this was a serious situation.
Did the Commonwealth put in any evidence of the defendant's age?
No,
Why not? Why? I mean, isn't that very important here? Or couldn't it be?
There would be, I mean, it just wasn't an issue. I mean, I don't think. There was no evidence that he had a license. I mean, in the motion to suppress, there was evidence about youths in the area and looking youthful.
But your point, isn't your point that there's the actions, and there's reasonable suspicion that a crime is being committed because, regardless of age, the police officer could reasonably suspect that this was somebody who didn't have a license to have this, what they thought was a firearm. Right?
Correct.
So
Correct.
the age is irrelevant for
Correct.
the reasonable suspiption.
Correct. Correct. And that, I mean, that's the way that he was tugging and fleeing, that it wouldn't have crossed their
And
mind.
Exactly at which point did the police officer draw his weapon?
The record is pretty clear. The defendant, when the defendant starts running, he has already cleared the police car, and he is about a car length away from them. He goes to a driveway. It's a pretty short distance, but he goes to a driveway. At that point, he has pulled out his firearm. He's tugging at it. He has pulled out his firearm at the driveway, and at that point, once the firearm is out, then Officer Bloss pulls out his firearm, and Officer Roby, who's behind Bloss, also pulls out his firearm.
So do the judge's findings make clear that it's only after the defendant has pulled out his weapon? I didn't read them as being all that clear, because he didn't do it exactly. He didn't contrast when this happened and when that happened.
When the defendant was grabbing at his waist, in the motion transcript, there was testimony from Bloss that he could see the handle of a pistol.
Right.
And then he was yanking at his waist, and then he was sure, and then it says, at the time the defendant approached the driveway, he had a firearm out of his pants, and then it says Bloss pulled it out. I mean, that's from the transcript, I think in the motion transcript, that the defendant had pulled it out, and Bloss had then pulled his gun out. And I think that's also consistent with the trial transcript testimony of Officer Bloss, too.
I want to ask you about the Apprendi issue. Do you think Heller and McDonald make a difference now with respect to the heretofore established law that having a license is an affirmative defense?
No, I mean, I think that Apprendi said nothing about affirmative defenses. It's just the Commonwealth has to prove every element, and the legislature
and licensing isn't an element. Is that what you're saying?
Right, and the legislature can choose to impose then the affirmative defenses, but the Commonwealth has to prove every element beyond a reasonable doubt. And also, if you look at Jones, the reason they say the reasoning is that under Chapter 269, Section 10, it prescribes inherently dangerous acts, and so the defendant has to show that his actions that he was within the exception of the prescription. So it was focused on the dangerousness of carrying a firearm, not necessarily that he doesn't have a right to carry a firearm.
And does Heller or McDonald change this vision of the dangerousness of carrying a firearm, since it's a fundamental right?
No, because I think that it is shown by the fact that Justice Scalia spelled out the sort of limitations and the qualifications, exemptions that can be that are recognized as people who are inherently dangerous.
Thank you, Ms. Celia.
Thank you, Your Honor.